Hi friends, welcome to UPSC World. This is Dr. Harinath Reddy, Faculty for Indian Polity and Constitution. Today in this particular video, we will try to look into the 14 questions which are referred to the Indian Supreme Court by the Indian President under Article 143. So we all know that Article 143 of the Indian Constitution confers advisory jurisdiction on the Indian Supreme Court, which means the President of India on any matter of public importance or even with respect to a pre-constitutional treaty can seek advice from the Supreme Court of India. This is what Article 143 deals with. Recently, the President of India, Draupadi Murmu, has referred 14 questions to the Indian Supreme Court in the context of the judgment of the Indian Supreme Court on Tamil Nadu governor. So most of these questions were already answered by the Indian Supreme Court in several other judgments. So let us see what are these 14 questions and how the Supreme Court has answered over a period of time for most of these questions and to what extent these questions are pertinent. Let's get started. The first question in the list of 14 questions referred to the Supreme Court by the President of India is: what are the constitutional options before a governor when a bill is presented to him under Article 200 for assent? So if you read Article 200 of the Indian Constitution, Article 200 of the Indian Constitution says that a bill which is passed by the state legislature, if it is referred to the governor for his consideration, the governor has got 4 options as per Article 200. First one, he can give his assent to the bill. Second one, he can withhold his assent to the bill. The third one, he can send it back to the concerned state legislature for its reconsideration. Fourth one, he can reserve the bill for the consideration of the president. These are the 4 options before the governor as per Article 200. And if you take the first option, giving assent to the bill, absolutely no problem. The second one, withholding assent to the bill. Recently, in 2023, in the state of Punjab versus Governor of Punjab, in this case the Supreme Court said the governor does not have an absolute veto with respect to a bill passed by the state legislature, which means the governor cannot withhold his assent to the bill. If he had any objections, he has to send the bill back to the concerned state legislature for reconsideration. So out of the 4 options, the second option of withholding assent to the bill is not allowed by the Supreme Court. The first option is yes, he can give assent to the bill. Second option, withholding assent, he cannot say no to the bill, he cannot reject the bill. That's what the Supreme Court, the Supreme Court said, if the governor has got any objection with respect to a bill referred to him, he can send it back to the state legislature for its reconsideration with respect to the objections raised by him. Then after reconsidering the bill, if the same bill is passed again, if the same bill is referred to the governor again, then the governor is bound to give his assent to the bill. So recently in 2025, this year, state of Tamil Nadu versus governor of Tamil Nadu, in this case the Supreme Court said, in the context of a bill which comes back to the governor after the consideration of the state legislature, the governor is bound to give his assent, that too within 3 months. The Supreme Court has laid down a time limit of 3 months for the governor to give his assent with respect to a bill which is sent to him, which is reconsidered by the state legislature. He cannot reserve it for the consideration of the president. When a bill which is already considered by the state legislature, if it goes back to the governor, in that particular stage, the bill cannot be reserved for the consideration of the president. That's what the Supreme Court said. Then when it comes to the fourth option is A bill passed by the state legislature can be reserved by the governor for the consideration of the president. In Article 200, it was laid down that there was one situation. A bill passed by the state legislature, if it affects the powers of the High Court, then such a bill can be reserved by the governor for the consideration of the president. That's what Article 200 says. There are other situations. If a bill passed by the state legislature is against the Constitution of India, if it is against the directive principles of state policy, if it is against the national interests, then in all these cases, the bill passed by the state legislature can be reserved for the consideration of the president. The second question, let us see the second question. Is the governor bound by the aid and advice tendered by Council of Ministers? So, if you take India, India is a parliamentary democracy. We have parliamentary democracy both at the union level and also at the state level. In a parliamentary democracy, the real power is conferred on the Council of Ministers headed by Prime Minister at the union level. And at the state level, the real power is conferred on the Council of Ministers headed by Chief Minister. The President is a nominal executive, Governor is also nominal executive. So at the state level, the advice given by the State Council of Ministers headed by Chief Minister is binding on the Chief Minister. This was laid down by the Supreme Court in one of the cases called Shamsher Singh versus State of Punjab way back in 1970s. Except in limited cases, in most of the cases, the governor is bound by the advice of the Council of Ministers headed by Chief Minister. This is also abundantly clear when Article 74 was amended by the 42nd Amendment. So the 42nd Amendment to the Indian Constitution in 1976 has amended Article 74, replacing the word may with a shall. Article 74 says, the President shall act on the aid and advice of the Council of Ministers headed by Prime Minister, which means before 1976, the wording in Article 74 is may, which means the President sometimes need not be bound by the advice of the Council of Ministers headed by Prime Minister. So Mrs. Indira Gandhi government, to make it absolutely clear that the President should always act on the aid and advice of the Council of Ministers headed by Prime Minister, she got the Constitution amended. So Article 74 amended by the 42nd Amendment to the Indian Constitution now says that the President shall always act on the aid and advice of the Council of Ministers headed by Prime Minister. Though the amendment has not made a similar change at the state level, this is binding even at the state level because, as I said earlier, we have parliamentary democracy both at the union level and at the state level. So this rule of the President acting on the aid and advice of the Council of Ministers headed by Prime Minister, it equally applies at the state level. Yes, under the Constitution of India, the governor has got certain constitutional discretion. For example, with respect to states having 5th schedule areas, so the peace and the good governance of the 5th schedule areas is entrusted to the governor. So with respect to administration of the 5th schedule areas, the President can consult the State Council of Ministers headed by Chief Minister. If there is any difference of opinion, the governor can act on his individual judgment. He has constitutional discretion. So with these exceptions, the governor is bound by the advice of the Council of Ministers headed by Chief Minister. And even this discretion which is given by the Constitution and the governor, it is a narrow discretion, not a very wide jurisdiction. This discretion cannot be used by governor for undermining the Constitution, for undermining the rule of law, because both the President and the governor, when they take oath of office, they say that they protect and defend the Constitution of India. They will remain loyal to the Constitution of India. So when they take oath of office, they clearly tell that they will bear true faith and allegiance to the Constitution of India and laws in this country. So which means even if the governor had constitutional discretion, this constitutional discretion cannot be abused, cannot be misused. These powers cannot be used by the governor whimsically. These powers must be used to uphold the constitution and the laws in this country. So this is the answer for the second question raised by the president before the Supreme Court. Let's see the third question. The third question is the exercise of constitutional discretion by the governor under Article 200 justiciable? This question is, if the governor of the state exercises discretionary powers under the Constitution of India, can it be subjected to judicial review? That is one question which was referred to the Supreme Court. And the Indian Supreme Court has repeatedly said in many cases that a judicial review is a basic feature. So judicial review cannot be taken away by constitutional discretion of the governor. So which means when the governors exercise their discretionary powers, when there is use of these powers, the higher courts in this country always have a right to intervene and to subject the actions of the governor to judicial review. So there can be judicial review on the actions of the governor when he exercises his discretionary powers. Because in India, we have constitutional democracy. In India, it is the constitution which is supreme, and all the three organs of the government, they derive their authority from the constitution. So it is not the three organs which are supreme in India, it is the constitution which is supreme. That is called constitutionalism. So we believe in the supremacy of the constitution, we believe in the rule of the law. So discretionary powers of the governor can't be used to undermine the constitutional democracy in this country. It cannot be used to undermine the supremacy of the constitution. Fourth question is Article 361 of the Constitution an absolute bar to judicial review in relation to the actions of a governor under Article 200? So we all know that Article 361 of the Indian Constitution gives immunity to both the president and governor. Immunity means protection. But remember, Article 361 gives protection to the actions of the president and governor in their personal capacity. But in their official capacity, whatever the president and the governor does can be subjected to judicial review. So that's the answer for the fourth question, which means while exercising the discretionary powers, the governor cannot take shelter under Article 361. So we cannot argue that what the governor has done under Article 200 while using his discretionary powers cannot be questioned because of Article 361. That is not the case. Then the fifth question, in the absence of any constitutionally prescribed time limit or manner of exercise of powers by a governor, can time limits be imposed and manner of exercise of powers be prescribed through judicial orders? The recent judgment of the Supreme Court in the case Tamil Nadu government versus governor of Tamil Nadu, in this case the Supreme Court has laid down certain timelines. I said a bill passed by the state legislature, if it goes to the governor, if the governor refers it back to the state legislature for the reconsideration of the bill, after reconsideration, if the bill goes back to the governor, then the governor is bound to give his assent within 3 months. The constitution is silent on this. But the Supreme Court has put a limitation, time limit. Can that be done is the question. It can be done. Why it can be done? We all know that in India, the Supreme Court is the final interpreter and the protector of the Indian Constitution. We say that the Supreme Court is the guardian of the Indian Constitution, protector of the Indian Constitution. So if there is any silence in the constitutional document on any particular issue, there is a duty and responsibility on the Indian Supreme Court to fill in these gaps in the Constitution. So under Article 200, the present Constitution of India does not put any time limit within which the governor has to give his assent. But the Supreme Court, by using its power of interpretation, has put a time limit of 3 months within which the governor has to give his assent. This is nothing wrong. This is the power which is well within the Supreme Court. So putting time limits is something which is allowed under the Constitution of India because the Supreme Court has the power to interpret the Constitution. So under Article 142, the Supreme Court, by giving a judgment, has put time limits on both the governor and the president in giving assent to the bills which are referred to them. This is perfectly allowed. Then the sixth question is the exercise of constitutional discretion by the President under Article 201 justiciable. See, I said under Article 200, a certain category of bills can be reserved by the governor for the consideration of the President. So once a bill goes to the President, Article 201 says, with respect to a bill passed by the state legislature, which is reserved for the consideration of the President has the following four options. He can say yes to the bill, he can say no to the bill, he can send it back to the concerned state legislature for its reconsideration, he can keep it pending. These are the four options. But take a situation wherein the bill goes to the President sends it back to the concerned state legislature for reconsideration. And Article 201 says, the concerned state legislature must reconsider the bill within 6 months. After reconsideration, if the bill goes back to the President again, then the President is bound to give his assent within 3 months. That's what the Supreme Court said. Which means, this is the intervention of the Supreme Court in the powers of the President. Is that allowed is the question. Is it justiciable? It is perfectly justiciable. No one is above the Constitution. No one is below the Constitution. So even if there is constitutional silence with respect to the time limit within which the President has to give his assent, if the President sits on the state bill for years together without acting on it, the Supreme Court has a duty and responsibility to uphold the Constitution and to protect the interests of the elected government at the state level. So the Supreme Court is well within its right to subject the actions of the President to judicial review and to deliver justice. That's what the Supreme Court has done recently. Under Article 142, the Supreme Court has passed an order doing complete justice to the people of Tamil Nadu by putting time limits both on the President and Governor with respect to the assent to be given by the President and Governor. That's the answer for the sixth question. Then the next seventh question. Can judicial orders impose the timelines and the manner of exercise of powers by the President under Article 201? This is the seventh question. So the question is about, can the Supreme Court tell the President of India the time limit within which he has to give his assent to the bills? Yes, the Supreme Court can do that. If the President sits on the state bills for years together, then how the governments at the state level can be run? And the President, while taking oath to the office, he himself says that I will bear true faith and allegiance to the Constitution of India. I will uphold the Constitution and laws in this country. So when you said that while taking oath, how can you go against it? How can you undermine the Constitution? How can you undermine the rule of law? That is not allowed. If such things happen, the Supreme Court is well within its right to intervene and can subject the actions of the President to judicial review. That's the answer for the seventh question. Eighth question. Is the President required to take advice from the Supreme Court when a bill is reserved by a governor for the President's assent? So the answer to this question is, it is not always required. For example, in 1958, the then communist government in Kerala has come up with the Kerala Education Bill to regulate the minority educational institutions in the state. This bill was reserved for the consideration of the President by the Governor. So the President has referred this matter to the Supreme Court for its advice under Article 143. So yes, with respect to a bill passed by the state legislature reserved for the consideration of the President, with respect to such a bill, if the President deems it necessary, he can seek the advice of the Supreme Court. And this happened in 1958 with respect to Kerala Education Bill. But it is not mandatory and compulsory to do in every case. It is left to the discretion of the President. If the President feels to take the advice of the Supreme Court, he can do it. If he feels that it is not necessary, he can keep away from taking advice from the Supreme Court. That's the answer for the eighth question. Question number 9. Are the decisions of the Governor and President under Articles 200 and 201 respectively justiciable at a stage prior to even the bill in question becoming a law. Is it permissible for the courts to undertake judicial adjudication over the contents of a bill in any manner before it becomes a law? A very intelligent question asked by the President to the Supreme Court, which doesn't have a sound basis. If you take the judgment in 2025 Government of Tamil Nadu versus Governor of Tamil Nadu, the Supreme Court did not go into the content of the bill. That was not the matter. The issue before the Supreme Court is both the governor and the president, they have not acted on the bills. So when they are not acting on the bills within a defined time limit, the Supreme Court has intervened and has put the time limits. So in this case, the matter is not about the content of the bill. The question is, even before a bill becomes a law, can the bills be referred to the Supreme Court? Here the question is, the constitutional validity of the bills was not in question. The constitutional validity of the bills can be questioned only after they become a law and if they come into force. But here the issue is not about the validity of the bills. The issue is about the president and governor not acting within a reasonable time frame. It's not about the constitutional validity of the bills. And as a result, this question itself is an irrelevant question because the Supreme Court has not said anything about the constitutionality of the bills. The Supreme Court has only said that the president and governor must act within a reasonable time frame. They cannot indefinitely delay giving assent to the bills. Question number 10. Can the constitutional powers of the president or governor be substituted by a judicial order exercising under Article 142? Here this question is again not a pertinent question. So under Article 142, the Supreme Court has the power to pass any order for doing complete justice. So the answer for this question is the Supreme Court has not taken over the powers of the president and governor. The president and the governor under Article 200 and 201, they are not acting. They are not fulfilling their constitutional duties and responsibilities. There is inaction on their part. The Supreme Court has only said that you should do your job. It has not taken over the powers of the president and governor. The question is asked in such a way as if the Supreme Court has assumed the powers of the president and governor. The Supreme Court has not assumed the powers of the president and governor. The Supreme Court only said that the president and governor as the heads of the constitutional heads at the union and at the state level must do their job within the reasonable time frame. The Supreme Court has not taken over the powers of the president and governor. That's the answer for the next question. Question number 11. Is a law made by state legislature a law in force without the assent of the governor? So this is an interesting question. In the recent past, all the bills passed by the Tamil Nadu state legislature, numbering around 10, which are reserved by the governor to the consideration of the president, even after reconsideration, the Supreme Court said, all these bills are deemed to be passed. Can that be done is the question. So if the governor is not doing his job of giving assent to the bills, if he is deliberately delaying the bills, then what are the options before the Supreme Court? Article 200 very clearly says, and the Supreme Court has clearly said, a bill passed by the state legislature, if it goes to the governor sends it back to the state legislature for reconsideration. After reconsideration of the bill again comes back to the governor is bound to give his advice. He is not, the governor is bound to give his assent, but the governor is not acting. He is not giving his assent. Instead, at this stage, he has referred it to the President of India to result in further delay. This is a clear case of undermining the constitution of the country. So in such a situation, by using its extraordinary powers under Article 142, with an intent to do justice for the people of Tamil Nadu, the Supreme Court said, all these bills are deemed to be passed. The Supreme Court can do this. Can such an action be done by the Supreme Court? Yes, Article 142 allows for doing complete justice. The Supreme Court can pass any order on any issue. So the Supreme Court has invoked its constitutional powers under Article 142 for allowing the bills passed by the state legislature of Tamil Nadu to be deemed to be passed. That is well within the rights of the Supreme Court. So that's the answer for this question. Let's move further. Is it not mandatory for a Supreme Court bench to examine if a case involved substantial questions of law regarding interpretation of the Constitution and refer the case to a bench of a minimum of 5 judges under Article 145 Clause 3? So this is a pertinent question. See, in the recent judgment given by the Supreme Court, it was not a constitution bench. It was not a bench consisting of 5 judges. It has a 3-judge bench. It was a 3-judge bench. But Article 145 Clause 3 very clearly says, if there is any question which is before the Supreme Court which involves interpreting the provisions of the Indian Constitution, such questions can be decided by a bench consisting of minimum of 5 judges. So this is something which is a pertinent question. So the powers of the governor and the president under Article 200 and 201 is the issue before the Supreme Court. Ideally, this case should have been decided by a constitution bench, a bench consisting of a minimum of 5 judges. But the case was decided not by a constitution bench, but by a bench consisting of only 3 judges. So this is a pertinent question which the Supreme Court has to answer. Nothing wrong with this question. Then question number 13. Is Article 142 limited to matters of procedural law, or does it extend to issuing directions contrary to or inconsistent with existing substantive or procedural provisions of the Constitution? The question number 13 is about the powers of the Supreme Court under Article 142. Is it a limited power or an unlimited power? Unfortunately, the Supreme Court doesn't have a single opinion on this. In some cases, like Union Carbide Corporation versus Union of India 1991, in this case, and in another such cases, the Supreme Court said the power of the Supreme Court under Article 142 for doing complete justice is a constitutional power. So the laws of the Parliament and state legislatures cannot impose any limitations on this power. That's one opinion of the Supreme Court. In other cases, like Supreme Court Bar Association versus Union of India, in this case the Supreme Court said the power of the Supreme Court under Article 142 to pass an order for doing complete justice is a limited power, which means this power cannot be used to substitute a law, to replace a law. It can be only used to supplement the law. So in the laws made by Parliament and state legislatures, if there are gaps, to fill in these gaps, the Supreme Court can use its power under Article 142. So these are the two kinds of opinion. In one set of cases, the Supreme Court said it is an unlimited power. In another set of cases, it said it is a limited power. And then, can the Supreme Court, by using its power under Article 142, can it go against the other provisions of the Indian Constitution? So for this, the Supreme Court said, say for example, Article 32. Article 32 speaks about constitutional remedies. So if any of the fundamental rights are violated by the state, you can go to the Supreme Court to get your fundamental rights enforced. So when the Supreme Court uses its power under Article 142, it should not come in conflict with Article 32. The fundamental rights guaranteed by the Indian Constitution cannot be undermined when the Supreme Court uses its power under Article 142. That's what the Supreme Court has already said. That's about question number 13. Let's move further. The last question is 14th question. Is there a bar on the Supreme Court from deciding between the center and the states other than by way of filing an original suit under Article 131? So Article 131 deals with the original jurisdiction of the Supreme Court, which is exclusive, which means if there is a dispute between center and state, between a state and state, the matter has to go before the Supreme Court. And the Supreme Court alone has to decide this dispute. The question here in the 14th question is, can that be done only under Article 131? Can a dispute between the center and the states, can it be decided even outside Article 131 is the question. For example, the judgment with respect to Tamil Nadu, state of Tamil Nadu versus governor of Tamil Nadu, this dispute was resolved by the Supreme Court, not by using Article 131. This dispute was resolved by using Article 142. Can that be done? Why not? It can be done. The Supreme Court can use Article 142, even Article 142, to decide a dispute between the center and the states. Similarly, there is one more article, Article 136. Article 136 speaks about special leave petition. This is again, remember, the power conferred on the Supreme Court by Article 142 and Article 136 is an extraordinary power. So by using Article 136, the Supreme Court can take before itself any case, even a dispute of federal nature between center and the states can be taken before itself under Article 136 and it can be decided by the Supreme Court. So here the conclusion is, a dispute involving the central and the state governments need not be decided only under Article 131. It can as well be decided under Article 136 and also under Article 142. That's the answer for the 14th question. So here we have answered all the 14 questions. So you may ask me a question. Who the hell are you to answer these questions? It is the job of the Supreme Court to answer these questions, as the President has referred them to the Supreme Court, not to you. That is right. But the Supreme Court has already answered these questions in several judgments which it has already given. So let us see if the Supreme Court responds to these questions in a different manner, contrary to what it has already said about these questions. But for you to have a greater clarity about these questions, the first point is you should understand these questions and you must be in a position to elicit an answer for this question. Maybe probably in the coming mains exam, one of these 14 questions can be a question in your mains exam in GS paper 2. Even in PSR optional, political science and international relations optional, PubEd optional, law optional, polity is part of these three optionals. So GS paper 2, PubEd, political science and the law, in the context of these 14 questions referred to the Supreme Court, any of these questions can be a question in your mains exam. So I tried to help you how to answer these 14 questions on the basis of the judgments given by the Supreme Court already. So that's it about the 14 questions referred to the Supreme Court by the President and how these questions are pertinent or not pertinent and what are the answers, possible answers which you can expect from the Supreme Court in the coming times about the presidential reference. That's it about it. Thank you and all the best.